If you don't care to bring it up in limine, that's your call as to when you want to make that motion, sir.
I think it would be best to do it now then.
Okay, let's go ahead and I'll read it now.
Sidebar, then for that?
We don't have the jury in here right now, so this motion's limine. You're fine. Go ahead and.
Sure. So the objection on the part of the defense is that the prior sexual assault is substantially more prejudicial than it is probative, despite the 413 rule. This is because the prior sexual assault under that statute, the prior sexual assault could be as mere as an unconsenting touching of the sweater twice, and in this case we have abduction, forcible rape, we'll be alleging tying up, and the prior sexual assault under that statute allows for the defendant's guilty plea in that case to reveal nothing in this case at all. And it is highly prejudicial because, of course, the jury may choose to find him guilty for a crime that he is not charged with today, and of course the propensity, although it's consistent with 413.
So you admit that it's consistent with Rule 413, but you're seeking to exclude it on what grounds?
The rules of evidence do allow 403 to trump 413 when the prior is not probative or too different than the crime that's charged with today. Today we have a forcible rape and abduction, and the statute that he was convicted of in the prior, again, could be satisfied by raising
Why can't I just deal with this with the jury instruction, or with a limiting instruction to the jury?
I think the name of the statute under sexual assault, despite the satisfaction of the statute being touching of clothes twice without permission, is just too prejudicial for the defendant. And because it's not probative of anything in this case, it should be excluded.
All right, let me hear the Commonwealth's position.
I take the podium, Your Honor?
Yes, please do.
Your Honor, we object to the barring of this evidence. As Your Honor knows, the very nature of 413 is because sexual assault crimes are different than any other crimes. That's why this law was created. That's why this rule of evidence was created. This is different. Propensity is overlooked because of this very rule.
There's no doubt that it is different. You're right on that, but there still is the 403 issue. So what standard should I be looking at this on a 403 issue?
Well, Your Honor, being that this is a past sexual crime, it is different from other crimes and therefore should not be held to the same standard as if it was another crime. This was a sexual crime in the past. It goes to show that the defendant would have committed a sexual crime that he's here for today.
If I let that in, isn't there going to be a sizable chance that the jury is going to convict, not based on what he's alleged to have done here, but what he's may have done previously, has done previously, conviction?
No, Your Honor. This evidence is substantially probative. Probative value far outweighs any prejudicial nature that it may have. According to Rule 413, in a criminal case in which a defendant is accused of sexual assault, the court may admit evidence that the defendant committed any other sexual assault. The evidence may be considered on any matter to which it's relevant, Your Honor.
All right. As much as I might have.
If I just maybe heard one more time.
Yes, actually, that'll be just fine.
Sure. Sorry, Your Honor, the prosecution just got here and told you no reason why this evidence is probative.
Well, they did actually. They told me that
other than it being categorized as sexual assault, the reason the rules allow for 403 to trump 413 in limited circumstances is so the prosecution cannot bring other sexual assaults that are unrelated to the sexual assault that happened.
Yeah, but that's kind of exactly what 413 does, and I may tend to agree with you that I've some problems with 413 due process. People that sit higher than I do disagree with me on that. So here's what I'm going to do. I'm going to let them lay a foundation. If at any point you think that foundation should be, you wish to voir dire on that issue or have some of that outside the hearing of the jury at the time, I'll let you do that. But I am going to let them lay a foundation for bringing that evidence in under Rule 413. And then we will deal with it then, but they will be allowed to make a foundation. What I expect from the Commonwealth is to just lay that foundation and to not let the genie out of the bottle too soon before I'm able to rule on that. Otherwise, I might be inclined to go with mistrial or prejudice.
Yes, Your Honor.
So just be careful with it, but you can lay your foundation. Very well. Okay. Any other motions? All right. The jury is in, and the Commonwealth, you may proceed with your opening statements.
Thank you, Your Honor. Halloween. A night of adventure, fun, and even mischief. Halloween 2015 started out that way for Ashley Jones. But then it took a dark turn. Being from New York, I know a thing or two about Halloween mischief. But you see, Ashley's mischief didn't take place out in the streets. No, it took place in a soft and comfortable bed, an otherwise safe environment. Ashley's mischief didn't take the form of a scary monster, wasn't a devil, wasn't a Halloween vampire. No, it presented itself in the form of an old friend, an ex-lover, the defendant, Peter Wells, did something awful, something terrible, sickening, when he took what he wanted by any means necessary and raped Ashley Jones. Members of the jury, today you're going to hear that Ashley and Peter had a relationship. That goes way back, all the way to the high school days. Peter left for college and they broke up. A few years later, both were attending George Mason University at the time. They ran back into one another. They started to hang out. They would go for drinks together, go to Peter's frat parties together, and occasionally they would sleep together. You're going to hear that that relationship worked well until it didn't. Members of the jury, on the night of October 31st, 2015, Ashley went to Peter's fraternity party. It was a Halloween party. Earlier in the day, the two had gotten into a fight, an argument. So Peter texted Ashley. He apologized to her. He invited her to come over to the fraternity house, promising her everything was going to be okay. He was going to be different. He was going to be a nice guy. This was new for Ashley. She had never heard Peter apologize to her before. So she accepted his apology and showed up at the fraternity house for the party later that evening. You're going to hear when she arrived originally, everything was going great. Two were getting along well. Dancing together on the dance floor. Peter was getting her a few drinks, laughing, having a good time. And then Peter asked Ashley to go up with him to his bedroom. Ashley was hesitant. She didn't want to. She was still upset about the fight that they had had earlier in the day. She told him she didn't feel comfortable going up to his room. But he convinced her. He convinced her to stay. And you're going to hear that once they got up to Peter's room, he told her that everything was going to be all right. And again, when she wanted to leave, he told her, just stay right here. I'm going to go and get you a drink. It's going to be okay. So you'll learn that Peter left Ashley in his bedroom, locked the door, giving her inside, went down the steps, and returned minutes later with a drink. He handed Ashley that drink. She took a sip from it, and immediately she started to feel funny. She didn't feel herself. She felt nauseous, she felt sick. Then she became almost paralyzed. She felt like she couldn't move. She told Peter to go downstairs and get help, maybe get her sister, get some friends of hers who were also at the party. So again, Peter left the room, locked the door, and he went down the steps. Disappeared for a few minutes. You're going to hear that Peter returned a few moments later, but instead of bringing with him help, he brought horror. You'll hear that when he returned to the room and unlocked the door, he saw Ashley laying there. You'll hear that the pain was terrorizing. And that leads us to our next charge, rape. In order to prove that the defendant raped Ashley Jones, we're going to show you that Ashley was totally drugged. She could not consent. She was paralyzed. She tried to get up, but she couldn't. She tried to get to the door, but she couldn't. Members of the jury, you're going to hear about this special drink that Peter promised Ashley. You're going to hear what it did to her. Now, today, Pat Hill is going to take the stand. Pat Hill is a sexual assault nurse examiner. And when he takes the stand, he's going to tell you that the morning after Halloween, November 1st, 2015, he examined Ashley Jones. And when he did, he found bruises all over Ashley's arms, down her wrists, on her hands. He took pictures of those bruises. We're going to show you those pictures today. We're going to show you what Ashley looked like after the attack. Additionally, a toxicology test was performed on Ashley the morning after Halloween. You're going to see that as well. When you see it, you're going to observe that the morning after Halloween, 10 milligrams of Ambien, a prescription drug, was found in Ashley's system. A drug for which Ashley did not have a prescription for. Members of the jury, I want you to listen to what Nurse Hill tells you the side effects are from mixing both alcohol and Ambien. And then I want you to hear what Ashley Jones tells you she felt after consuming that third drink on Halloween night. I want you to listen to those two, Nurse and then Ashley Jones. Ashley's going to tell you that she couldn't control her body, she couldn't move, and she felt the defendant inside of her. It wasn't a monster, it wasn't a devil that brought about Ashley's horror that Halloween night. It wasn't a vampire that robbed her of her sense of security. It was an old friend. It was an ex-lover. It was somebody who she knew, somebody that she trusted, the defendant. We ask that you find the defendant guilty on all charges. Thank you very much.
Opening statement from the defense.